In this lecture, we consider three cases. The first two provide early law regarding tribal jurisdiction over non-members, Williams versus Lee and United States versus Missouri. That's Mazary rather than Missouri. The third case, Oliphant versus Suquamish, is a criminal case, but it effectively resurrects the dormant or non-existent notion of implicit divestiture, triggering a fundamental shift in Indian law and opening an era of modern judicial diminishment of tribal sovereignty. Although few tribes had criminal justice systems recognized by non-Indians in the 1800s, several early treaties did acknowledge criminal jurisdiction over non-Indians. Such treaties include the 1785 and 1786 treaties with the Cherokees and Chickasaws, the 1789 treaty with the Iroquois, the 1825 and 1865 treaties with a variety of Northern Plains tribes, and the 1868 treaty with the Navajo, among others. For the most part, federal authorities accepted the reserved rights doctrine during the 19th and most of the 20th century, assuming the tribes retained jurisdiction within their borders over members and non-members alike, unless a federal statute or treaty specifically removed that jurisdiction. This is especially the case in matters of civil regulatory jurisdiction. For example, in 1934, Solicitor Nathan Marigold described the powers of Indian tribes in a solicitor opinion as follows. Over tribal lands, the tribe has the rights of a landowner as well as rights of a local government, dominion as well as sovereignty. But over all the lands of the reservation, whether owned by the tribe, by members thereof, or by outsiders, the tribe has the sovereign power of determining the conditions upon which persons shall be permitted to enter its domain, to reside therein, and to do business, provided only such determination is consistent with applicable federal laws and does not infringe on any vested rights of persons now occupying reservation lands under lawful authority. This executive branch acknowledgement of tribal authority is consistent with the foundational principles and the reserved rights doctrine as articulated by Chief Justice Marshall in the Marshall Trilogy. I emphasize this in order to demonstrate that Chief Justice Rehnquist's assertion in Oliphant versus Suquamish, on which the entire line of modern cases judicially divesting tribes of authority, that there was a general assumption by all three branches of the federal government that tribes lacked criminal jurisdiction over non-Indians, is simply false. As the court stated in Williams versus Lee in 1959, discussed 2 lectures ago, first, Congress has acted consistently with the assumption that states have no power to regulate the affairs of Indians on a reservation. And second, the cases in this court, the court said, have consistently guarded authority of Indian governments over their reservations. Essentially, absent governing acts of Congress, the question has always been whether the state action infringed on the right of reservation Indians to make their own laws and be governed by them. Accordingly, the Williams Court held that state courts could not adjudicate a conflict that arose on the Navajo reservation between Navajo citizens and a non-Indian trader. Rather, the tribal court was the appropriate forum. As the textbook authors state, because there was no indication that the non-member merchant had overtly consented to tribal court jurisdiction, and no federal statute or treaty purported to confer jurisdiction on the tribal court, the case stands for the proposition that inherent tribal sovereignty includes jurisdiction over such causes of action. The United States Supreme Court similarly recognized tribal sovereignty in United States versus Mazary in 1975, where the court upheld a delegation of federal authority to tribes. Martin and Margaret Mazary operated a bar on non-Indian fee land on the Wind River Reservation. 2 federal statutes, 18 U.S.C. 1161 and 18 U.S.C. 1154, delegated authority to tribes to regulate liquor trade on their reservations. Further, those statutes made it a federal crime to sell liquor in Indian country without compliance with both tribal and state laws. When the tribal governments refused to renew the liquor license, the Mazarys continued to operate their bar, and they were prosecuted by the United States Attorney. The Mazarys argued that the tribes were merely private voluntary associations and therefore Congress could not constitutionally delegate lawmaking authority to them. Ruling against the Mazaries, the court emphasized that tribes are sovereigns with independent subject matter authority, and that Congress may delegate federal authority to them. As sovereigns, the tribes are, according to the court, a good deal more than private voluntary associations, and they possess a certain degree of independent authority over matters that affect the internal and social relations of tribal life. We now turn to the modern judicial divestment or diminishment of tribal sovereignty, and we start with Oliphant versus Suquamish Indian Tribe, a 1978 criminal case. Although Oliphant is a criminal case, the reasoning, as we will discuss, was extended to cover civil matters 3 years later in Montana versus the United States. Given the significance of Oliphant and the Montana line of cases, it is worth discussing in this course as well as in a criminal jurisdiction course. Mark Oliphant was a non-Indian resident of the Port Madison Indian Reservation who was arrested by a Suquamish tribal police officer for assault on a police officer and for resisting arrest. He requested a writ of habeas corpus in federal court, claiming he was not subject to tribal authority. In an opinion by then Justice Rehnquist, the court agreed with Oliphant. The Oliphant case flipped Indian law on its head by asserting that tribes lacked criminal jurisdiction over non-Indians absent an express delegation of authority by Congress. Although Congress had never taken away tribal jurisdiction, Justice Rehnquist relied on scant historical evidence and ignored the treaties cited at the beginning of this lecture to assert that there was a shared assumption among all three branches of the federal government that the tribe lacked criminal authority over non-Indians. According to the majority, criminal jurisdiction by Indians over non-Indians was inconsistent with their dependent status. Thus, for the first time since the Marshall Trilogy, the court declared tribal authority implicitly divested, though Congress had taken no steps to limit it other than through the Indian Civil Rights Act of 1968. Recall that that statute provided statutory rights similar to those in the Bill of Rights, just the sort of rights that Justice Rehnquist feared non-Indians would be denied in tribal courts. Justice Thurgood Marshall, joined by Chief Justice Burger, dissented on the basis of the reserved rights doctrine. Quote, "I agree with the court below that the power to preserve order on the reservation is a sine qua non of the sovereignty that the Suquamish originally possessed. In the absence of affirmative withdrawal by treaty or statute, I am of the view that Indian tribes enjoy, as a necessary aspect of their retained sovereignty, the right to try and punish all persons who commit offenses against tribal law within the reservation." Nevertheless, the court declared that because there was a shared assumption found by the court among all branches of government that the tribe lacked authority, and because exercise of that authority was inconsistent with their dependent status, that the courts no longer had that authority. Oliphant and the judicial divestiture doctrine that it began have been widely criticized by scholars, and critics come from across the scholarly spectrum. I share this because you might feel some frustration, and this will let you know that you're not alone in feeling frustration over the court's departure from a century and a half of precedent and the court's decision to exercise authority that it had routinely said Congress alone held. For a century and a half, the court said that only Congress can take away tribal authority, and if it does so, it must do so expressly. But in Oliphant, the court flipped Indian law on its head by saying, absent a delegation by Congress, we assume the absence of tribal authority. For example, Professor Krakoff, in an article entitled Undoing Indian Law One Case at a Time, noted a pernicious assumption underlying recent Indian law cases that tribal sovereignty is a dated notion and that it should be scaled back to comport with non-Indian expectations. Similarly, in 2002, Dean Swagey wrote an article entitled The Supreme Court's Whack-a-Mole Game Theory in Federal Indian Law, where he described the Rehnquist Court's jurisprudence as so arbitrary as to amount to a whack-a-mole game in which Indians are the moles and the court wields the hammer. David Getches, late dean of the University of Colorado School of Law, wrote an article entitled "Beyond Indian Law: The Rehnquist Court's Pursuit of States' Rights, Colorblind Justice, and Mainstream Values" in 2001. In that article, he described the court's jurisprudence as result-oriented jurisprudence, ignoring or misapplying the canons of construction, injecting a balancing of interests where it is unsupported by precedent, and resurrecting assimilationist policies long since rejected by Congress. Similarly, Professor Gloria Valencia Weber wrote an article entitled "The Supreme Court's Indian Law Decisions: Deviations from Foundational Principles in the Crafting of Judicial Smallpox Blankets." In that article, she concluded that recently, the court produces Indian law without the substance and doctrinal authority due from a constitutional wall. Frank Pommersheim, professor at the University of South Dakota, wrote an article entitled "Coyote Paradox." There, he observed recent developments in Indian law, particularly at the United States Supreme Court, threaten the well-understood and precarious balance with a new, almost vicious historical amnesia and doctrinal incoherence, a doctrinal incoherence that spawns unpredictable ad hoc decision-making and increasing potential to destabilize and to capsize modest tribal efforts and accomplishments in the area of self-determination that is allegedly at the heart of federal policy in the modern era. Ralph Johnson and Barry Martinez wrote an article entitled "Chief Justice Rehnquist and the Indian Cases" in 1995, describing Rehnquist's Indian law opinions as advocating and implementing a judicial termination policy. And finally, late Professor Philip Fricke wrote in 1999 and 2000, "A Common Law for Our Age of Colonialism: The Judicial Divestiture of Indian Tribal Authority over Non-Indians," describing a normatively unattractive judicial colonial impulse beneath the dignity of the best qualities of federal Indian law and the unstated but clear deviation from precedent by the Rehnquist Court. I note these observations so that you can see that even where a court's decision is final, and Justice Breyer often says, we are not final because we are infallible because we are final. You can see that courts still issue decisions, whether it's Dred Scott or Lone Wolf or Oliphant, that are subject to criticism and may have long-standing precedential effects. Next, we will continue our discussion of judicial diminishment of tribal authority over non-members, specifically looking at the time period between 1981 and 1997. That opens in 1981 with Montana versus the United States and ends in 1997 with Strait versus A1 contractors.